Hi, welcome to HR Insights with SN.
Today, we will be discussing how to prevent and save your organization from wrongful termination and dismissal as HR manager. Our guest is Barrister Ire Oguntuase, Principal Partner, A, O, and G, and Associates. Welcome to the show.
Thank you, SN.
You have been in the labor markets, or will I call it, you've been in the system for quite a long time. What has been your experience? Please share with us.
Yes, my experience has been quite interesting. I've been able to handle a lot of matters at the National Industrial Court. I've been able to, as much as possible, right the wrongs, of employees who have been wrongfully terminated. Most instructively, I think there was a matter I handled where the HR practitioner, after terminating someone, after the employer has already tendered the resignation letter, she now went ahead to terminate the employee's employment. And I found out as extremely wrongful and unfair because it's like beating a horse that is already dead. So, those are the kind of experience that you see in practice. There was actually another matter that I handled whereby the employees are involved in trade union activities, and the employer, as a result of that, went forward to terminate their employment. Those are the kind of things that you see in the Nigerian labor setting. And all those things are not uncommon, considering the fact that Nigeria is still a developing country, and also considering the paternalistic approach of the employers, to employees generally, thinking that they have the right to do and undo. But fortunately, the National Industrial Court is there to right the wrong. So the experience has been quite very interesting.
So for how long have you been in the industry?
Well, I've been a lawyer for the past 10 years.
Okay.
And I actually have been majoring. I've been handling National Industrial Court matters, I can say, since when I was called to the Nigerian Bar. But I found it as a passion to major in labor law for like 8-9 years now.
Oh,
so
wow.
I've been very consistent within that
Okay.
space.
Before we dive into the drama properly, because it's been a lot of drama in the employment, environment.
Sure.
What's the difference between termination and dismissal?
Now, when we talk of termination, basically, what we're trying to say is termination is a way of bringing a contract of employment to an end. But we need to understand one thing. There are several types of termination. We have termination by notice, we have termination by breach, we have termination by performance, we have termination by agreement, and most importantly, we have termination by dismissal. So we need to understand one thing. Dismissal is one of the ways of termination.
Yes,
But again, apart from dismissal, there are several other ways of termination. So dismissal is infused as one of the ways of termination. But most importantly, we need to understand the fact that ordinary termination of an employment does not suggest a wrongdoing. But dismissal in itself suggests a wrongdoing. So dismissal is usually as a result of gross misconduct.
Yes, please.
Now, in the case of Boston Deep Sea Fishing and Ice Company against Ansel, gross misconduct is defined as any conduct that is grave and weight in character as to cast aspersion on the relationship of confidence that exists or to exist between an employer and the employee. So when you're talking of dismissal, dismissal is the punitive type of termination. Dismissal is termination as a result of punitive conduct on the part of the employee. And dismissal carries with it, an implication that the employer has actually committed a wrongdoing to an extent that the employer no longer wants to proceed, in the contract of employment with the employee. But termination is different. If a contract of employment is ordinarily terminated, that can be by agreement, that can be by performance, that can be by notice as contained in the contract of employment. But when we're talking of dismissal, we're talking of an existential wrong that the employee has performed, upon which the employer now decides to terminate the contract of employment. So there are consequences that comes with this. Now, when an employer dismisses, the implication is the employee, the termination takes immediate effect without recourse to what is contained in the contract of employment. So if an employer dismisses now, the dismissal takes immediate effect, and the employee cannot claim that the employer did not give him or her 1 month notice or 1 month salary in lieu of notice. But when it comes to termination, what we're saying is that either of the parties, they have the right, they are terminating the contract of employment. So even one difference that exists between termination and dismissal is that either the employer or the employee can terminate, but it is only the employer that can dismiss. So dismissal is the right that accrues to the employer because the employer has committed a misconduct. But when it comes to termination, is a right that accrues to either the employer and the employee. Now, for an employee can terminate by giving notice. An employer can also terminate by giving notice. So that's just the difference.
Is it safe to have those kind of misconduct captured somewhere, maybe on terms of agreements, so that the employee will understand that, okay, should you do this, this is actually the appropriate sanction for you? Because I've seen instances where the employer terminates or dismisses the employee, and few months down the line, the employee comes with, or the former employee now brings a lawyer to fight the organization for wrongful dismissal, because I think that is actually the bone of contention.
Okay, now, before I even go ahead to address the issue of wrongful dismissal, we need to first address something. Like I said before, dismissal is a right that inures to an employer. So an employer can dismiss whether that right is expressly stated in the contract of employment or not. We need to understand that very clearly. Now, but one thing we also now need to understand is that whether or not the employer can dismiss, that condition, that behavior of an employee need not be contained in any way. For example, there are acts that are generally considered as gross misconduct. For example, maybe stealing, maybe fighting. So if the act is perpetrated or committed by the employer can go ahead to dismiss, save that the employer also follows the appropriate procedures. Because there are appropriate procedures that are attached to dismissal. And if the employer does not follow that, then that is when wrongful dismissal that you mentioned can come in. But it is not the position of the law that the conditions or the conduct, the dismissible conduct upon which the employee will be dismissed needs to be expressly stated in the employee handbook or contract of employment. Although it makes it very easy if it is contained in the employee handbook or contract of employment. I would suggest or I will advise that it is contained. But if it is not contained therein, it doesn't mean that the employer cannot dismiss. And I'll give you this example. Assuming drinking of alcohol is the employer considers this as a dismissible offense, but it is not contained in the employee handbook where the list of dismissible offenses are considered. Does it mean that the employer cannot dismiss as a result of the employee being consistently engaging in drinking alcohol? Of course, the employer can do that, but there are some conditions in which the employer will follow, upon which it will now be clear, that the employer intends to dismiss. And if the employer fails to follow this condition, that is when we can now say that, okay, a claim of wrongful dismissal can arise or be justifiable.
Can you just spell out those conditions, statutory conditions?
Well, when you say statutory conditions, I wouldn't say it's statutory. I would say they are precedential conditions. And they are precedential conditions because it has been established over time, in cases that have been handled. Now, the two conditions are, they are just Latin maxims. We have what is called audi autarem partem, which means hearing both sides. And we have what is called nemo judex causa sua, which means you cannot be a judge in your own case. And I will explain. Now, for audi autarem partem, if an allegation which is capable of causing dismissal has been made against an employee, now, the employee has a right to respond in defense to that allegation. And if I bring it down, that is query, or that is forming of a disciplinary committee. So that means the employee can either respond in writing, that's if a query is given, or the employee can either respond orally by inviting the particular employee to the DC. Now, let me say that in the case of Valentine Ikechukwu Chiazo against Access Bank, it has been held that giving a questionnaire will never suffice as a query. So there are two different things. So those are the things that people really need to understand. So as far as these conditions are concerned, an employer needs to fulfill the procedure of audi autarem partem, that is, give a query. give the employee reasonable time to respond to the query. And nemo judexin causa now to the effect that the person that made the allegation against the employee will not be the same person that would determine the fate of the employee.
Yes,
and I'll give you an instance. Assuming the human resource personnel in a complaint has made out an allegation of stealing against the particular employee. Now, will it be appropriate for the human resource practitioner, for the human resource manager to be part of the panel that will determine the fate of the employee when he or she is the one that made out the case of stealing? Okay. So that is a practical application of the nemo judexin causa. And all those things are very important. They're important because it's even embedded in the Constitution, Chapter 4, Section 36 of the 1999 Constitution. That's right to fair hearing. So the two conditions are the pillars of the principle of fair hearing. So in all, before the employer can dismiss an employee, it must be seen or it must be noted that the employer has really adhered strictly to the principle of fair hearing as contained in the Constitution.
From our headline sponsors, partners, and producer, we say a very big thank you for staying tuned.